we are seeing a recent concerning trend from USCIS where they push up certain steps of the process to make it more difficult for applicants to supply critical information and evidence in order to affect approval for their cases. Stay tuned to find out more. When you submit an application, a petition, or any other kind of request with USCIS, they would typically issue what's called a request for evidence if they find anything that is deficient in the application form itself or the supporting evidence. This is what we lawyers like to call a second bite of the apple. It's a second chance for you, the applicant, to supply the information and evidence that's needed to help your case get approved. Now, typically, the RFE would come with very specific instructions on what information to supply and what evidence to submit to make the case fully approvable. You, the applicant, are expected to comply with those instructions thoroughly. Whatever they ask, you provide. So, what happens if you fail to respond to the request for evidence? Well, if you make a good faith effort, you try to supply some information and evidence, and still they find the information deficient because you didn't read the instructions carefully, for example. Well, typically they will give you a third bite at the apple. USCIS up to this point has been historically lenient about these sort of things. Doesn't always happen, but more often than not, I think we see notices of intent to deny before they do anything else. This notice of intent to deny is a final notice, a final warning. They're saying that if you still do not provide the evidence or information they need in your next response, then the next action they take is to deny your case. So USCIS, historically relatively lenient, but that might no longer be the case because we are seeing a recent trend, as reported by a lot of my colleagues and from my own experience, where USCIS is skipping the RFE, they're skipping the NOID, they might go straight to denial if they see any sort of deficiency in either the form itself or the evidence. Let me share with you one of my cases just by way of example. A client came to me with a denial notice from USCIS for their I-485 form to adjust status into a permanent resident. Originally, they received an RFE because the form, on the form, they did not fill out some critical information about public charge. USCIS issued an RFE asking them to answer those specific questions, but in addition to that, also date and initial each one of the questions. Now, you understand this. The client is busy. They're a full-time professional. They read the form quickly and they're eager to answer the RFE quickly so that they can get their green card sooner. But in their haste, they neglected to not just answer the question, but to also initial and date next to each one of the questions. In about a week and a half, USCIS came back with a denial notice. And the reason for the denial is that the client did not initial and date the questions that they answered. I think we can all agree that this is a very harsh outcome, given just how easily the applicant, my client, can correct these mistakes. From what I spoke about earlier, it seems that a notice of intent to deny an NOID would have been appropriate in this situation, but, as I mentioned before, USCIS is now taking a much stricter and harsher stance in dealing with all those simple errors. Fortunately for my client, there is still a way to rescue the case. If you receive a denial, you can submit what's called a motion to reopen or motion to reconsider. Those are two separate motions, but both are filed on the same form, I-290B. With a motion to reopen, you're asking USCIS to consider the information they previously did not have. Motion to reconsider, on the other hand, is arguing that the agency should reconsider their decisions because their previous decision fell outside of their established policy. The way to succeed in any immigration case is to argue all the arguments that are available to you. So when I'm submitting the I-290B form, I am submitting both a motion to reopen and a motion to reconsider. And very broadly, here's the basis. With the motion to reopen, my thinking is since my client did not supply the information that USCIS needed, even though she answered the question, she didn't really initial and date them. Well, USCIS couldn't really use those answers when it was analyzing my client's case. So the solution there is pretty simple. You just answer the questions and date and initial as originally requested in the RFE. Simple. And just in the interest of thoroughness, because I don't like to leave anything to chance, we also filled out an I-485 form, just completely new one, as an addendum, as amendment to the form that my client originally submitted. This is really just to be sure that we're supplying multiple different options that USCIS can take. I know some of my colleagues might think that I'm overdoing this, but I just don't like leaving anything to chance. So that's motion to reopen. As far as motion to reconsider is concerned, I think that there is sufficient room for us to argue that USCIS should have issued a notice of intent to deny. There is a memo that USCIS released back in, I think, 2021 that specifically discussed their established policies about issuing RFEs and NOIDs. While it is true that officers generally have discretion to issue RFEs and NOIDs as they see fit, the memo does list some of the reasons on why they should issue RFEs and NOIDs, including critically when it seems some information or omissions can be easily corrected. So that's the memo I submitted. I also submitted some passages from USCIS's policy manual. Remember, the strategy is thoroughness, right? I want to pursue all possible arguments and all possible avenues so that I can ensure success for my clients. And it worked. After the I-290B was submitted, we got an approval in about a week and a half. That was not what I expected, but it's very welcome. It's always welcome when USCIS acts quickly. My client's I-485 was also approved and their green card is underway. I have seen this too many times as a lawyer. There is a mindset amongst a small group of people, an unfortunate mindset, where if you don't understand a question, it's okay not to answer it. I think those people also secretly hope that immigration officers don't care that much about those questions. And that is just not a good strategy to take. Some information are more important than others in immigration form, true. But a good practice is to thoroughly fill out all the questions that you can answer. Some of the questions might not apply to you, and it's okay to leave them blank, or what I like to do is just to write N/A for not applicable. But by and large, you are expected to be able to provide thorough information when you're submitting an immigration form. If you don't, you risk going through the situation that my client went through. You might have to respond to an RFE and then waste more time on your case. In the worst case scenario, maybe they don't even bother with an RFE now. They would just deny your case outright. So, general rule of thumb, always answer your immigration forms thoroughly. And if you can't, because you don't understand some of the questions, that's what you hire a professional for, right? Or if you receive an RFE or notice of intent to deny, read the instructions carefully, take your time. You're given usually a couple of months worth of time to respond to those documents, so take your time and fully understand them before you respond. And as always, if you don't understand what they're instructing you to do, seek professional help. And that's all we have for today. If you have any questions, like I said just earlier, talk to us. We're happy to talk.